Aaron Hughes, is he here? Okay. Step up here if you would. We're going to have our Deputy Attorney General, Brian Stock, just go over a couple things with us here.
Okay, so just to start out with, as far as the conflicts of interest, since I know the Nevada Outfitters and Guides Association sent a letter to the commission. However, I've stolen that back from all the commissioners because this court is now sitting as an administrative law court, and so it's not appropriate for them to take input from the community or from the public on the outcome. So we've taken that out of the record. In addition, if any of you have had any personal or business dealings with Mr. Hughes or anyone within the third degree of consanguinity or affinity, so let me just tell you who that is. That's your children, grandchildren, great-grandchildren, parents, brothers, sisters, nephews, nieces, grandparents, uncles, aunts, or great-grandparents. Then you should recuse yourself and not participate in hearing the appeal. So if any of you have dealings with Mr. Hughes, you should say so now. And okay.
Mr. Chairman, I need to recuse myself.
Okay.
Do we need a reason?
No.
Okay, so noted.
Okay.
Should we put it under oath?
Not yet. So, just for the boards, just to let you know what we're doing here. When we get to the end of this, you'll make a decision on Mr. Hughes's appeal, and that decision will need to have, in the motion, will need to have findings of fact and conclusions of law. And so what you'll need to do as the hearing is going on is think about the facts that are meaningful to you, because when the final opinion comes out, it has to be based on what's called substantial evidence. And that's any evidence that a reasonable person could rely on to come to the same conclusion. Now, the standard of evidence is fairly relaxed, and so we don't have all those hearsay rules and those things you see on TV, but you need to give evidence the weight it's entitled to. So anything that's speculation, it may be admissible because of the relaxed rules, but it's not something that a reasonable person would rely on generally. So those are the kinds of things I wanted you to talk about. The burden's on Mr. Hughes to prove that he should get his guide license back by a preponderance of the evidence. And the way they kind of visualize that is 51%. In other words, if it's 50-50 in your mind, then Mr. Hughes loses. So he has to bring it up to 51% and the department at 49% in your mind. I understand there's a conviction in the Justice Court for this violation. The board can't take any action contrary to that conviction. So in other words, the board can't pretend that never happened, because this board doesn't have the authority to reverse what the Justice Court did. Okay? And I think that's about all I wanted. So when you get to the end, just make sure the motion has findings of facts and conclusions of law, and then what I'll do is I'll put those into written form so that whoever is disappointed today will have the chance to appeal that administratively to the district court. That's all I have.
Should we put them under oath, though?
Yeah.
Who does that? Commissioner McBath.
Dag Stockton, I would like one clarification on the citation. There are some legal principles, and I'm not sure which one is applicable here. It's the doctrine of collateral estoppel or res judicata, and so you've mentioned that we can't do anything, we can't attack the citation. But what I would like to understand is how binding is the citation on this issue that we're dealing with. In other words, are we going to be able to go behind it and even discuss it, or do we just have to take the fact that that there was a citation issued and that he agreed to it, he pled to it, or whatever the whatever the disposition was or defaulted. I can't really tell from these documents. But what is the, what is, are our hands tied with respect to that issue?
Yes. That's a short answer, but I don't think Mr. Hughes disagrees. He knows what, I mean, he's kind of admitted what happened. He doesn't disagree with that. So the commission doesn't have any discretion to look back at that offense, and I don't think Mr. Hughes is going to ask you to. The discretion you have is agencies, and I'm sorry to take up so much procedural time, but agencies need to be consistent. I know in the case law you'll read that agencies aren't bound by their prior decisions, but I can tell you from personal experience that if you want to enforce this law ever, you have to enforce it evenly for everybody. So the only reason we're having an appeal here is under the guide statute, it's discretionary with the commission whether or not to revoke the license. So the fact of the citation and the violation are a done deal. The commission can't change that. What you can do is find maybe mitigating factors or something like that to, or come up with some penalty less than, it's not revocation, it's non-renewal of his license. Does that make sense?
Mr. Stockton, the actual fines that he's paid, are we could give that any weight in our decision?
As in, I mean, it's evidence and mitigation, the fact that he paid a fine. I guess you could say that's part of the penalty already. I don't know. That's a factual question. I can't really answer that. You have to decide whether that's worthy of weight or not. See, that's a choice for you to make. It's not really a legal conclusion. The fact is out there that he paid the fine, but I can't tell you how to use that.
Okay, Suzanne, can we swear him in?
Can I print the oath you put out your tables?
Say that.
The oath, I put it.
I gave her
He should have given it to you.
I have it here.
you printed it out and left it here. You want me to just do it? I mean,
Yeah.
All right. Mr. Hughes, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir, I do.
Thank you. Okay, Mr. Hughes, what we're going to start is we're going to have, I'm going to have you present your evidence, your case, and then we can be cross-examined by the department and then questioned by the commission. That's how we start, okay?
Okay, Mr.
So, go
Chairman.
ahead.
First of all, I'd like to thank all of you for your time. I won't take up very much of it. I want to give an explanation of the incident, and I'm not looking for any type of action from the board. I just want you guys to understand the incident on which I was cited where I paid the fine. I had two clients come into an area 10, that I was booked with. I had an individual who was obtaining his sub-guide license, told me it was on its way. I did not check on that from the game department. That's my fault. And I had assigned him a client for another area 15. It's approximately 70 miles across the dirt between these two areas. I had a camp set up with two clients in area 10. 5 o'clock the evening of the arrival of my client for area 15, this guy calls me and says, I can't do it. I can't take this guy out. They never approved my license, so on and so forth. Which, of course, if any of you are in business, you know, I began to call all the other guides around, see if anybody was available that could take him down, take care of this guy. He had already paid for a hunt, so on and so forth. Nobody was available. Make a long story short, what I ended up doing was I was in camp with my two clients in area 10. I would put them to bed about 10 o'clock at night. I would drive to Eureka from Buck Mountain and meet with this guy to apologize, number one, for what had happened. The guy had been applying in Nevada for 6 years and finally drew a tag that he wanted. Of all things, he was a bonsai tree salesman. That's what he did. And so he was spending his days going out, looking and digging up juniper trees. And I said, well, if you see something, then I can break away from my camp and I can come over and we can go out there and take the animal. He never did take an animal. He was refunded all of his money, of course. And it was a bad situation. It was just horrible. And if any of you are in business, I assume you can imagine what position that put me in. I felt bad about it. In any case, Endow had been tracking him for about 4 days. And he told me, he told me a lot of things, but he was not impressed. They came to me and they wrote me a citation for not accompanying him in the field. And I said, okay. I was upset, signed the citation, planned on going to fight in court, did not, sacrificed the bail, and so here I sit. And I'm not going to go on forever, but a couple of things I'd like you guys to consider. This is a citation. If a truck driver gets a citation, the company doesn't go out of business. If one of your cows busts through the fence and is on the wrong grazing allotment and they catch them, they don't shut down your ranch. When it comes to income, guiding is not a huge income. I'm not out making $1 million a year guiding. I enjoy Nevada. I love Nevada. I love the wildlife in Nevada. I've been supportive of the wildlife department. I taught hunter safety for a decade. I've always been very supportive of Nevada, and my clients that I bring in, I don't bring in people out of Vegas or Reno that just happen to draw a tag. I'm bringing people in from the East Coast. I'm bringing people in from California. I'm bringing people in that make a lot of money. And so then you have a trickle effect here that when these people come in, there's a lot of money going into my community, into these little tiny Taylor Canyon Resort, into Montello, into Wells. An average, I think the studies show $6,000 per person. And if I average 15 clients, that's a lot of money you're cutting off for a citation. I humbly ask that you think about this as far as business perspective. Think about the state of Nevada. Think about the recession. And then we sit here in front of regulations after regulation after regulation and control and control and control, and they want to take away my guide business for a citation. So I'm just asking that you consider my appeal, nothing more, nothing less, and I appreciate your time.
Thank you. Cross-examined by the department.
For the record, Rob Bonamici, Chief Game Warden for the state of Nevada. With regards to this issue, Mr. Hughes, have you been employed in law enforcement in the past?
Yes.
Okay, so you're aware of regulations and that we are required to enforce those regulations?
Absolutely.
And do you understand that regulations should be equally enforced across the board?
Mm-hmm.
Okay. So have you ever been asked by individuals that you've cited, why didn't you get the other people? They're doing things wrong.
Well,
Why'd you pick on me?
I'm sorry, I'm not disputing the citation, Mr. Bonavici.
Okay,
I'm not disputing the citation at all.
that's all I have.
Thank you. Any questions by the commission? Commissioner Cavan?
Mr. Hughes, this was a non-resident guided hunt tag.
Yes, sir.
Okay, just want to make.
Commissioner Rain?
Thank you, Mr. Chairman. Question, and actually perhaps it's of both individuals, did not come out clearly to me, was the client actively hunting in the absence of Mr. Hughes? Was he actively hunting?
He was. He certainly had his eyes open for deer.
And
He wasn't shooting anything.
was he carrying heat in
I
the
believe
field?
he was. Yeah.
Okay.
Yeah.
And is that the conclusion of law enforcement that he was actively hunting in the absence of his guide? I'm,
Oh, you gotta
wait
till the department.
oh, sorry. Thank you.
Commissioner Macbeth, did you?
I have a question of Chief Bonamici.
Mr. Chairman?
Commissioner Capero?
Thank you, sir. Mr. Hughes, you were licensed as a guide for both areas 10 and the other area that you were actually
That's
not
correct,
able to. So you were legally licensed for that to begin with.
Yes, sir.
That's really the only question I
I had a question, Mr. Hughes. We have a letter here from Joe Maslach, game warden, that you had 3 additional violations for violating terms of the special use during 206, 207, and 208. Is that correct?
I'm unfamiliar with that letter, sir.
It was. Mhm.
That's the guy. This is Aaron Hughes. That's the guy for July.
Okay.
Yeah, June.
Oops.
Sorry.
No.
I missed the.
Forget that. Is any,
Yeah.
Commissioner Capero?
There was one other thing I wanted to ask. What kind of conflict was there when you talked to the game warden? Were you upset?
Oh, I
Were
definitely was upset, sir. Yeah.
Were you aggressive? You did understand why he was doing what he was doing?
I did, and signed the citation, and there was no, I wasn't so upset that I was aggressive and in their face or anything like that, no, sir.
Commissioner Cavan?
So when did you appear in court?
I did. I appeared for an arraignment. I paid, at the arraignment, you pay your fine, so then you can go back to court if you choose to go back to court. What I did was I paid the fine. I was going to go back and fight the charge. I didn't go back. And then my assumption was the court just kept your money, and they issued a warrant. I had to call them and say, whoa, I'm sacrificing my bail. I'm not. Does that make sense? So the court actually issued a warrant when it didn't show up, and I called him and said, well, I thought that the money that I gave you, like a speeding citation, they just absorbed that. And he said, that's not correct in Eureka. And so I said, well, I'll sacrifice my bail and accept a conviction then on the citation.
So were you aware at that time that if you accepted the citation that you were, or when you didn't show up in court to plead your case there, that you were going to basically forfeit your guide's license?
Absolutely not.
What was the distance between your guide and the hunter? I got a map here, but that looks like a long way away. Huh?
It's a long ways from what's called Buck Mountain all the way across Diamond Valley to Eureka, and I made that at night. I got back to my camp about 2:30, was up at 4:30 with my clients. I was trying to get my 2 clients, their animal, in Area 10, so I could go over then and accompany my client in 15, but they couldn't hit anything.
Long way. Commissioner Raines?
Just one for the, now you'd in testimony that you had instructed your client to not hunt unless he was in your presence.
I told him not to shoot a deer. So
Okay.
I guess it's, maybe it's my, when you're hunting to me, but obviously we don't feel the same, or now I understand better that being in the field with a rifle is hunting rather than shooting an animal. He did not take an animal. I told him if he found an animal, I even told him places to go. I said, you can look here, glass. I'm completely, I have no choice here. I have nothing I can do. Glass for an animal. If you find an animal, that's why I would drive across every night and meet with him and say, did you find anything? No, nothing I'm looking for. Okay. So.
And just to follow up on this, so he was actively walking, he wasn't just driving around in the vehicle with a weapon, he was actually walking out in the
He's
field.
definitely an outdoorsman. Not to mention he was backpacking trees off the mountain, so.
Commissioner Howell?
There was never any time when he was in an area where hunting wouldn't have been permissible.
No, sir.
Yeah. So, to a casual observer, he could have been hunting coyotes.
That would have been my argument in court had I taken it to court.
Yeah. You don't need a license.
There's a little problem with that factually in that Mr. Hughes already admitted his client was looking for deer, so
Yeah.
making a factual finding like that would not be appropriate.
And again, gentlemen, I'm not arguing the conviction of the citation. That's not my point. I hope you don't take it that way.
Mr. Hughes, do you agree that a guide is ultimately responsible for their hunter no matter what they do?
Oh, absolutely. Yeah, and this has been a tough lesson to learn, but boy, did you sit in front of a commission over here, you learn a pretty valuable lesson.
Anybody else have questions? If not, I'll turn it over to the department to present their evidence, and then they could be cross-examined by you, Mr. Hughes, and then questioned by the commission afterwards. Go ahead, Ms. Bonamici, present your evidence.
I'm not sure, are you going to give testimony or just talk about, because do you want to, we need to swear you in, put you under oath if you're going to testify.
Whatever you want to do.
You better.
I'm going to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the whole truth and nothing but the truth under penalty of perjury?
I do. Again, for the record, Chief Game Warden Rob Bonamici. Before you have a series of exhibits, and I'll just go through those real quick. Exhibit 1 is Aaron Hughes' denial letter for his 2010 Master Guide license. And Exhibit 2 is his request for hearing predicated on that denial. Exhibit 3 is the support for that denial, Mr. Hughes' citation and record of conviction. Exhibit 4 is the client profile, further showing that Mr. Hughes was cited. The citation did go to warrant. And then Exhibit 5 shows that the warrant was cleared up and therefore the conviction. Now Exhibit 7, this is kind of like the hunting in the wrong unit type situation. We're not talking 100 feet over the line, 100 yards over the line. In this case, we're not talking 5 miles over the line, 10 miles over the line. We're talking a great distance. And the guide regulations are real specific when it comes to the non-resident guided deer hunt, that the hunter must be accompanied by a guide. Now we have a myriad of other guides that are involved in the non-resident guided deer hunt program. They do it correctly, and so in this situation, we felt it was egregious enough to, in a fairness to all the folks that are out there, all the guides that are doing it correctly, it needed to be addressed. We couldn't just let this, slide through the cracks. On April 28th, Exhibit 8 is Mr. Hughes's notification of the hearing today. So in a nutshell, that's our exhibits for the case. I think it's important to remember that guiding is not a right, it's a privilege. And there are very definite rules when it comes to guiding. We take it serious. These individuals, in one fashion, represent us, the Department of Wildlife. We license them. That's our stamp of approval. We feel in this instance, we should not provide that stamp of approval. Now, that's not to say he can't come back in next year and apply, and we'd reconsider, but I think staying out of the game for a year is appropriate based on the severity of this violation. It's only a misdemeanor, but it is a pretty major violation. And it is a major violation in the eyes of the other guides as well. They take it serious, we take it serious, and we expect the master guides of this state to take it serious.
Mr. Bonamici, would you, for the clarity of the commission, would you read the regulation, what about the hunter has to be and guide has to be a hunter at all times? If you would read that for the commission so we understand it thoroughly.
Yeah, if I could get a copy of that,
I've got it here if you want me to read it.
you got it.
Somebody read it for the
502,
commissioners.
149.
I think we'll let Mr. Bonamici read it.
Okay. This is the one regarding reasons for denial. The reasons for denial are in NAC 504671.
No, I meant the one that he violated,
Oh, for
not being
the,
in possession of his hunter.
oh, okay.
I have it right here. It's real simple.
Yep.
The NRS 502.149, guide to accompany hunter during hunt. A restricted non-resident deer hunter must be accompanied at all times during the restricted non-resident deer hunt by the licensed master guide who co-signed the application or one of his licensed sub-guides.
Every commissioner understand that? I needed that clarified for the commissioners. Thank you. Any other questions, Commissioner Howell?
Rob, he lost, he didn't have a license in 2009 at all then. Is that right?
Who, Mr. Hughes?
Yeah.
I believe he did. Did you have, I don't,
I actually missed the deadline for the application, so I was not licensed in '09, so I reapplied this last year.
Yeah.
Commissioner Burrow?
Thank you, Mr. Chairman. Bonamici, is there any flexibility in the rules with respect to the penalties that can be applied? In other words, can you suspend a license instead of denying the application? Or are there other penalties that could be imposed other than the dismissal of the application?
there are penalties. We could suspend a guide's license, revoke or suspend. NAC 504671. The department may deny an application for, or revoke or suspend a guide license for any of the following, and then the laundry list of the criteria. So yes, we could suspend. What we save the suspensions for are extremely egregious violations. Guide goes out, shoots client's deer, that type of stuff. In those cases, we would not wait till the renewal period comes around again. We would pursue suspension upon the conviction. If that was in the middle of the hunting season or what have you, and try and shut that behavior down as soon as possible. So this is, in our minds, warrants some form of action. But it isn't, I'm not here saying that he killed deer for 5 of his clients or anything like that. But it still warrants, in our estimation, some serious consequences.
Commissioner Rain?
Thank you, Mr. Chairman. I'm just going to look, I'm assuming that you took some things into account, but I should ask you about them rather than assuming them. In the investigation, you took into account that, and you investigated that the client was not doing things in violation of his orders from his guide, looking for mitigating circumstances. you look into that? And the conclusion of investigation, as far as that went, was that, I mean, it wasn't the client. I mean, it wasn't that the client heard what the guide said and did the total opposite, or how would that work?
It was a situation where the client knew his guide was supposed to be with him. The client admitted to knowing that. The client was hunting. In fact, I believe Mr. Hughes met with the client prior to him being out in the field and gave him maps of where to hunt and all that. Mr. Hughes stated to the client that his sub-guide could not make it because I believe the sub-guide's sister was killed in a car wreck, which is not true. So we did do an investigation, and we came to the conclusion that this was intentional violation committed by Mr. Hughes, and he knew what the laws were. He's in law enforcement. He knows how to read laws. So based on that, we felt that a citation was appropriate.
Commissioner McBeth?
I have just one question, in a search for any mitigating, circumstances here, I'm just curious, has Mr. Hughes ever been cited or convicted of any other violations?
Yes, sir, he has. Since this incident, he has been cited for failure to remove expired numbers on his boat, on his vessel. So he was cited by our game warden and paid an $82 bail, forfeited an $82 bail on April 29th of 2010. So just 2 weeks ago. And he was also cited, not germane to the statute regarding and the regulation regarding guides, but in conjunction with that for expired trailer plates.
Any other questions? If not, Commissioner Kevin?
Chief Bonamici, if I understand the situation where, his client shows up, so would he be in violation of another law if he'd have just blown this client off and said, hey, I can't accommodate you? And is there some other, I was reading the laws, and there's a lot of them, and if you don't treat your client right, that's also a violation, I guess is my question. So where would we be if he told his client, no, I can't accommodate?
I'm sorry, I'm going to have to stop you. It's not appropriate for a court to decide a case based on hypotheticals. You need to decide based on the facts that are presented to you.
Commissioner Howell?
Rob, if today we're voting on his appeal for 2010.
Correct.
And we could very well be right back here doing the same thing next year, if he applies next year.
Not necessarily. And I say that because, like I said, this is a serious violation, but it is not the most serious violation.
It's not forever.
It's not forever, but we feel, yes, it deserves sitting out for a year. And if he applies next year and there are no other convictions, we're going to look at that.
Commissioner Capero?
Thank you, sir. The the violations that you mentioned with respect to the boat numbers, I'm assuming that's the boat registration numbers, like if you're registering your boat to be used on waters in the state of Nevada, and conversely, I assume that the fact that his boat trailer registration, the sticker wasn't up to date, was part of the same violation. Is that correct?
That is correct. The The boat trailer, separate issue. The motorboat violation under NAC 504671. One of the provisions is two or more convictions of any provisions of Chapter 484 or 488. 488 is our boating.
Had he not paid for his boat registration and it just left the numbers on, or had he just not replaced the numbers on the boat?
He had not replaced the numbers on his boat.
So he had paid for his boat registration.
I believe so, yes.
May I clarify?
Just, I'll let you cross-examine them, and that's the next, as soon as we get all the commissioners' questions out of the way. Is there any other questions? If not, I'll have ready to have Mr. Hughes cross-examine Mr. Bonamici. Go ahead, Mr. Hughes.
Okay. Just in reference to that citation, there was two numbers from an old California registration still on the bow of the boat. I did have my Nevada numbers and registration on the boat, so, but they cited me for the two old numbers that were on there. So I paid the fine, just to clarify. Mr. Bonavici talks about a penalty or to sit out for a year and that, we'll reconsider next year. We would probably be sitting here again next year. That would be my understanding of that. We want to talk about a penalty for a moment. Are there penalties you can impose? My $1,500 application fee, I guess, would be a penalty if it's upheld because they keep it. I have missed the non-resident deer draw application period for the guided draw, which is 90% of my business. That was due a long time ago, which I couldn't partake in because of the denial. I have already paid a penalty for this. And I don't have anything else to say. I'll leave it to the commission.
Any questions? Commissioner Capurro?
Thank you. I guess the point that I wanted to pursue was whether or not the violation would become an issue that could be brought up next year when he applies, or if he applies for a master guide license next year. You had indicated that probably only issues that came up from the time of the removal of the license until the next licensing period would be considered. In other words, if you had another ticket for something or other, you would not take into account what led up to this removal of his license if he applies next year?
If he applies next year and there are no further convictions of any sort on Mr. Hughes's record, then yes, we would look favorably at renewing that license.
And my last question
Or
comes...
approving it, I should say.
My last question comes with respect to, again, the question I originally raised about alternative penalties. Theoretically, could you have cited him and then have him pay a fine for what was done and not dismiss his application for licensing?
The process is we issue the citation, and then it becomes a matter between the defendant and the court.
But doesn't the department have an administrative penalty, Mr. Stockton?
No.
No.
Okay. That's it.
Commissioner Moore?
Thank you, Mr. Chairman. Rob, is it the department's authority when one applies for a guides license to make the determination whether they are eligible and for if they are ineligible for the period that they are ineligible for?
That's kind of a legal question, so let me answer that. Under Nevada Revised Statutes 504390, under, I think it's subsection 9, or anyway, that the period of non-license renewal is maximum of 5 years. So I would assume that this commission, as part of your motion, could decide how long not to exceed 5 years, that Mr. Hughes would not be able to renew his license.
Commissioner Howell?
The department's not asking for anything but 2010. Denial for 2010. That's all they're asking for, right?
Correct.
So we couldn't vote to make it 5 years then.
The statute says not more than 5 years. The commission says, right, let me just read it for you. If any licensee under this section or person served by license, convicted of violation of any provision of this title or chapter 488, the commission may revoke the license of the licensee and may refuse issuance of another license to the licensee for a period not to exceed 5 years.
So the answer to that is we could. Any other questions? If not, we'll have Ms. Bonamici and Mr. Hughes present any rebuttal evidence and then be cross-examined by the other party, but on issues limited to the rebuttal. So, Mr. Hughes, do you have any rebuttal evidence on issues?
No, Mr. Chairman.
Mr. Bonamici?
Yeah, one comment, if I may. With regards to Mr. Hughes' statement of minimizing the registration, the decals on the boat, simply had the old numbers and Nevada numbers. That's no different than, hey, I moved here from California and keeping my California plate on the car and the Nevada plate on the car. One's on the front, one's on the rear. What's the big deal? Paid my registration. So, you know, and in light of being in law enforcement, that's something that individual should be fully aware of.
Okay, let's go into closing arguments by Mr. Hughes, and then we'll have closing arguments by Ms. Bonamici.
I think I've pretty much said everything. All I am just humbly asking you guys to really consider shutting down a business, taking away income from the community over a misdemeanor citation. When we talk about penalties, I've already paid a pretty heavy penalty. I haven't been able to apply clients. I've lost a lot of clients. They move on to another guide. When they can't apply, they don't get their bonus points. You guys know how hunters are. I know how I am. I am trying to rebuild a business. That's what I'm doing. I don't think there's anything that I could have done differently, maybe in their eyes, but ethically in my eyes with this hunter. I told him don't shoot an animal. I don't know what else I could have done differently. I gave him his money back. Promised him another hunt for free. I've paid a pretty heavy penalty for this citation already. And I just thank you for your time and consideration.
Okay, closing arguments by Ms. Bonamici.
Thank you, sir. This is not solely about a business. It's about fairness and equity to all the guides, all the sportsmen out there that play by the rules. That's one issue. The other issue is Mr. Hughes portrays his business, being very serious about his business and so forth. Somebody that's very serious about their business would make sure that they follow the rules, don't put themselves in a position that jeopardizes their business. So, you know, to what level of seriousness he takes his business is a choice that, you know, the commission will have to make here. Other than that, boils down to fairness, doing the right thing, and we felt we've done the right thing.
Okay, thank you. Now the commission has to deliberate, and then we have to we have to render orally a decision here based on the findings of fact for the Attorney General. So I'm going to bring it back to the commission to deliberate openly here. Commissioner Cabrera.
Sir, can I ask Mr. Stockton, kind of following up on the point that you stopped Commissioner Cavan from bringing forth, can I ask you if there would have been, had he blown off, so to speak, his hunter, indicated that he couldn't hunt him after he had already contracted, I assume that could that hunter file a complaint with the department, and could he have been cited for not properly taking care of his hunter?
You know, I assume it would be a violation. I assume there could be a citation, but I mean, the problem is you've got to decide the case based on facts, and since that didn't happen, you know, I guess from the angle that was another choice he had to make that may have been worse or something like that, you can take that into account, and then maybe as a mitigating factor, he made the best choice he could under this circumstances. But you can't decide the case based on that. You need to decide the case based on what happened.
I understand that. I was wondering whether that wouldn't come under mitigating circumstances, though, number one. And number two, that it's a catch-22. If, in fact, in the instance I just described, they could have cited him, that would have been a misdemeanor, too. And they could have withheld his license because of that, too. Wouldn't that be true?
Right. But
Thank you.
But we need to decide the case based on the facts.
Based on this,
Okay.
I understand.
You know, the fact is, we have a law, and it says you must accompany your hunter. And if you don't accompany your hunter, you violate the law. And you have to be with him. We just heard it read. So it seems pretty black and white that did occur. And there's a reason that it's in the regulation like that. And if you can't get out to do your hunter, you tell him to stay in camp, and I'll get out to you. But the law says you can't have a guy out in the field without accompanying him. And that's a fact of law. And I don't think we can change that. Commissioner McMahon.
You know, in an attempt to try to find mitigating circumstances, you look at a situation like this, and it's, I have mixed feelings. But in the end, what Chairman Lent is saying is true. And furthermore, I'm concerned that if we start creating exceptions here and allowing, first of all, I don't think we have the ability to do any kind of alternative sanction. There is no penalty provision. It's either we agree with the department or we don't agree with the department. The department has indicated that it's only going to, that they're interested only in a 1-year suspension. I'm concerned with not making a statement to the guides in general in the state that this is a serious matter and it has consequences, and we can't make exceptions in these kind of circumstances, and we're not given much discretion to make any kind of exceptions. I just don't want it to be a message that we send that says, well, you got one bite at the apple, and so therefore, we're gonna, if we basically say that the department is not, proceeding, properly here, then we're gonna create an exception that means that we, to be fair, we're gonna have to do this for any other guide that does the same thing. And so that's the piece that really concerns me. I would have liked to have seen Mr. Hughes actually been more involved on the front end of this citation and maybe try to work out a deal with the department and get an attorney. I know it's tough dealing with attorneys, but, you know, that's where the effort should have been. But the facts that we're presented with here have been admitted by Mr. Hughes. There is no doubt that he has admitted that he violated this regulation, and so you know, when I try to weigh whether we should have some kind of a mitigating circumstance to say that the department isn't correct or not, I have to side on the side of you know, the policy that we should be setting as a commission to, and the message we should be sending on this kind of a violation, that it has serious consequences, and that I think what the department is doing here is really the minimum that they could do, you know, under these circumstances. And so, you know, for that reason, I would have to agree, you know, with Chairman Lent, and I'm just extending it one step further and saying, from a policy standpoint, I think that's the correct decision.
I don't think this commission takes pleasure in any of these hearings, but I'm basing my ideas on a personal experience I had in Alaska, where I was told to stay in camp because the guide was coming in on a plane and he was taking another hunter out, and I was not allowed to leave camp to go hunting till that guy got rid of the other hunter and got into my camp, was guiding me, and because they're responsible for the hunter. And I think it's obvious in the regulation, and there would have been alternative things to tell the guy to stay in camp till I can get somebody to hunt with you, you know, one of my guides. And so I think that's where I'm coming from, because you're ultimately responsible for your hunter. Any other questions? Or Commissioner Cavan?
Mr. Chairman, Brian, could you read us this 504671?
Which is that? Okay.
That's it's NAC.
Sure. Let me find it real quick.
It has to do with grounds for denial of the application.
I got, just give me 1 second to pull it up. Oh, wait, it's on here. Okay, so it starts out. It's the title is 504671's ground for denial, revocation, or suspension of a license, and it starts out: the department may deny an application for, or revoke or suspend a guide's license for any of the following. And then the one that Mr. Hughes was cited under is subsection 6A: a conviction of having violated a provision of Chapter 488 or Title 45 of NRS, or any regulation adopted pursuant thereto, or for a conviction of having violated an equivalent provision in the law or regulations of any other state or the federal government. So that's the subsection that he was convicted of.
But it does
Or
say,
that's the grounds for the denial of the renewal of the license.
it does say the department may deny, not must or shall or.
It does. And that's the only reason we're here. If it said shall, then the district court would be binding on us and we wouldn't have anything to do.
I guess if we think it's a serious enough violation to do this. Commissioner Howell.
Thank you, Mr. Chairman. I appreciate the fact Mr. Hughes was in a catch-22 situation, but in hindsight, which is always 20/20, it would seem to me he had a choice to call somebody in law enforcement and get some advice. Tell them the situation and maybe get some advice.
Any other comments by the commission. If not, we need a motion, either one or two ways. We find these violations are substantiated and revoke it for X number of years, and show the department properly revoked his license. And we need to tell in the motion why we're denying it, or we can say Hunter made a good faith to correct, and we're giving him one more chance under that effect. So those are the two decisions I think we have to have in a motion. One of those two, since it says may. Am I correct? And we should, we need to tell why we're denying it in the motion. So, we need the facts for the Attorney General.
We're gonna do Mr. Chairman, we're gonna do finding as fact first before the motion, is that?
They could be in the motion. Just say, we're doing a motion due to, why we're denying it, and that's the finding of facts in the motion.
Can we do finding of fact and then come up with?
You could, they should be in the motion, but if you want to do it that way.
Well, I think he wants a successive motions, do it first a
Sure.
findings of fact motion, then a conclusion
Sure.
of law motion, then a.
I'd have no problem with
That's
that.
kind of where I was going, so that we don't have
Yeah.
to articulate
Okay,
everyone's wishes. And if I articulate a motion, it may not include some finding of fact
Okay.
that someone else has on there.
there wouldn't be a problem with that.
Mr.
Commissioner
Chair,
Howell?
thank you, Mr. Chair. Mr. Chairman, our motion, I think, should include the fact that the department is asking for the denial of his license for 2010. That's all, 1 year.
Should be in the motion,
If,
the time. Anybody want to make a motion? I guess I could, but if we don't get somebody going.
but that's why we had the attorney.
Huh?
I'm not on the board, I can't make.
No, I'm talking about the one sitting next to you.
Oh, this,
I'm writing a few down, but if he's got something,
I'll make a motion, if someone does, but
just trying to come up with all encompassing here.
Mr. Macbeth, if you want.
Yeah.
149, wasn't it?
This one right here, 502-149.
502. 502.
Is that what you're looking for?
You want me to make a motion?
Yeah. Okay, I'll go ahead and take a stab at this. I'd like to make a motion setting forth findings of fact. I think the first finding of fact would be that Mr. Aaron Hughes had contracted with a hunter, a non-resident hunter pursuant to the restricted non-resident guide hunt. This hunter had a tag to hunt in Area 115. The second finding of fact would be that Mr. Hughes did not accompany the hunter during the hunt for Area 115 as required by NRS 502.149. Mr. Hughes was cited by the department for violation of NRS 502.149. And finally, Mr. Hughes in effect, pled guilty or conceded that violation of NRS 502.149. So that would be the motion for the findings of fact.
Without me repeating it, no, we need a second before we can discuss it.
Second.
We have a motion and a second by Commissioner Morai. Did everybody understand the motion? If so, I'll call for a vote on the motion. All for the motion. Commissioner Rain?
Mr. Chairman, one thing, if we could, I'd just ask the maker of the motion if it would be appropriate, maybe we could just discuss adding it to, or would be that sufficient mitigating circumstances did not exist to, I'm trying to think of the wording, lessen the penalty? That would be a finding of fact, if, is where I'm getting at.
Be a conclusion of law.
Is that a conclusion of law?
You can do that as a second motion.
I'm just trying to figure out if that would be appropriate now.
I'm just not sure if, you don't know what the penalty is yet, because you haven't said what the penalty is going to be, so,
To reverse the department's,
okay, to reverse.
would it be appropriate to say sufficient mitigating circumstances do not exist to reverse? So what we're doing here, what we would potentially be doing would be reversing the department's actions. Because that's what I'm thinking is the root.
I guess by not making a finding of fact at all, we're in effect saying there are no mitigating circumstances.
Should we state that?
Would that be more of a conclusion?
That's why I'm trying
That
to,
one could go either way. You can do it if you want to, I'm not,
Mr. Chairman, it seems to me like that would be in the conclusions of law. If you decide, in fact, to uphold the department, that would be part of the conclusion of law, that to buttress why you didn't, why you supported the department.
so this wouldn't make, okay. Thank you for allowing me to clarify.
Well, we have a motion and a second. Everyone understand the motion? Let's call for the vote. All for the motion, say aye.
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 Anyone opposed? Motion passes. Now, we have to have a motion. On a resolution.
Six, seven, 6A. No, it's NAC, that's.
Here you go.
Assume he's gonna make it, huh? That's a good answer.
Conclusions of law, so we should have one should be legally violated this section. 6, 7, 8, that's grounds for denying his license. Local fire, hospitals, denies license for
I'll assume we raise their hands.
If I could,
Commissioner Rains?
if I could just throw something out without making a motion here, what we're talking about is what sounds like where we're going, and what I found is sufficient mitigating circumstance did not exist to reverse penalty of revocation of guide license for 2010.
Well, actually,
Is that the way it should be?
actually, no, you're not reversing. This is what's called a de novo hearing, so it's, you're making a decision of your own. It's not reversing the department.
Okay, for going against the departments, what's a better way of stating that?
How about if you just said the departments submitted sufficient evidence to show that
That mitigating some circumstances did not exist?
or that
Findings show the
Mitigate-
department properly revoked his license.
well, okay.
Revoked his
They didn't
application.
revoke it, they
Denied
his
it, denied it.
Denied his
That's all you
application.
need to say if you want to do that.
Would-
No mumbo jumbo. Commissioner Capurro.
Wouldn't the, and again, I'm not making the motion either, but wouldn't the conclusion of laws be, number one,
Make finding of fact.
that there was a violation of the named articles
Was
that
convicted.
that we've already moved on,
That's good. We
and
just made a finding
the
on it.
language that Mr. Stockton indicated that, in conclusion, then, there were no the mitigating circumstances.
Or
The
insufficient.
department and the commission found no mitigating circumstances to do anything, I don't know what the language would be. different.
Overrule the department.
Overrule the
Does
department.
anyone want to make a motion?
I'll make the motion.
Commissioner Capurro.
I'll make the motion that we indicate that that the articles that were part of the findings of fact, there were, what, 3 of them? That those were.
Well, the section he was cited under is NRS 502.149.
But that's in one of the articles of, if I'm not mistaken, isn't that correct? It's in one of the findings of fact
Yeah,
that he
that was the third
violated
one.
that,
Well,
or that there
the
was a
findings of
violation.
fact or what he did to violate it, the conclusion of law is that it was violated.
Okay. So that we could say in the motion that he violated the issues that were set forth in the articles. Now, you may have to word it differently, but in the articles, in the findings of fact, and that there were no mitigating circumstances presented by the defendant or in the discussion to reverse the conclusion.
You want to say for
That'd be
1
all
year?
right.
Gotta say for 1 year.
It's up to you guys.
Want me to restate it? You can just clarify it.
What's that?
Want me to just restate that, please?
Ask him.
Commissioner Cabral, would you like me to maybe just clarify, try to clarify it a little bit? Okay. I think,
I was
you know-
waiting for you.
Okay. Well, I was working towards it. I was trying to get it straight in my mind. I guess what I'd like to do is amend Commissioner Caparro's motion to make a conclusion of law that Mr. Aaron Hughes violated NRS 502.149, which states a restricted non-resident deer hunter must be accompanied at all times during the restricted non-resident deer hunt by the licensed master guide who co-signed the application or one of his licensed sub-guides. Further, that the department pursuant to NAC 504.671 has properly denied the application to revoke or suspend Mr. Hughes' guide license based on a conviction of having violated a provision of Chapter 488, is this 488? Yeah. Of Chapter 502 of NRS. And that's it. That's as simple as it is.
Is that for 1 year? Do we have to?
And that the commission further finds as a conclusion of law that at the request of the department, that the period of revocation will be for the hunt year 2010, and that Mr. Hughes may reapply at that for the 2011 hunt. And that obviously his application at that time will be considered on the situation at that time, but would not conclude the violation that he is being sanctioned for here.
Gee, I like what I said.
Okay.
Second.
We got a motion, do you have the motion down, Suzanne? We have a motion, and we're gonna need a second on it.
I second.
Commissioner Cavan seconded it. Does everybody understand the motion without rereading it? If so, let's call a vote on the motion. All for the motion, say aye.
Aye.
Anyone opposed? Hearing none, motion passes. Let's take a
Wait, one more.